873, make 873. আর অন্য সব কাগজ সরিয়ে দিন, কোনো একটা কাজে লাগবে না।
পেজ 30 মিলছে না বলছে,
873 টা দেয়নি।
আমারটা তোমার কাছে চলে যাচ্ছে, আমারটা তোমার কাছে চলে যাচ্ছে।
14th of September 2016, the result of TET 2014 was published, but no merit list and scorecard was given to anyone. On 26th of September 2016, notification was published for appointment of primary teachers from TET 2014 to fill up 42,949 vacancies. In that notification, it was clearly stated that the candidates with minimum qualification as specified by MHRD will get preference, and after that, eligible candidates with relaxed qualification may be considered. It is needless to mention, is important, that MHRD gave relaxation only till March 2016, and in spite of that, the board notified that the candidates who do not have training will be considered too. Notification proves that the board decided to get benefit of relaxation to TET 24 qualified candidates. I shall place this notification later. Then paragraph 10 is important. Your petitioner states that after notification, the procedure was started for appointment, and from October to December, the interview and verification process started, and on 31st of January 2017, allegedly, the result was declared, but there was no panel. There was no merit list. There was no category-wise merit list. No division of numbers and or rank was given to anyone. In website of the board, there was a dedicated space where the person could see whether he or she was empaneled or not. No merit list was ever published. And in spite of repeated requests, the full merit list was not made to the public. Allegedly, it was stated on 30th January 2017, list of trained candidates were published. On 4th February 2017, list of non-trained candidates other than the Bengali medium was published. And on 8th of February 2017, list of non-trained candidates and candidates from Bengali medium were published. From the dates and list, it is clear that all trained candidates of 2014 were appointed to the first list. And after completion of the same, as per notification dated so and so, the board appointed non-trained candidates. Then Lordship may come to paragraph 11. Just I am reading out, Lordship need not be detained for that. In paragraph 11, down the middle, it is alleged that thousands of non-trained students were appointed, and petitioners, though similarly placed, were ignored. If it is the stand of the board that no non-trained candidates can be appointed, then all appointments of non-trained candidates made after March 2016 are bad in law. Then paragraph 12. Your petitioner state that recently TET 2014 scam busted in West Bengal, and from several cases lodged by CBI and from several orders passed by this honorable court, the petitioners came to know that several illegal appointments have been given by depriving the petitioners. Non-trained candidates are the worst sufferer of this scam. On 23rd December 2020, the West Bengal Primary Education published one notification for recruitment of 16,500 primary teachers. And in that publication, they have stated that the candidate should possess qualification as per guidelines of NCTE. Such notification is illegal. I am just skipping over. Then Mr. Y was empaneled. A person named Mr. Y having roll number such and such was empaneled by the board. It also proves that huge corruption took place. As per the action of the board and as per the different statements given by the president of the board, Mr. So-and-so, all trained candidates were recruited, and as per the notification of the board, the petitioner should get a fair chance of recruitment, but the board has done a complete injustice to them. Then paragraph 13.
Then what was the allegation of the petitioner? 2014 was corrupted. Which is your allegation?
State 2014 corrupted, and even the selection process were,
This paragraph does not say so.
yes.
Paragraph says that it is state 2014 corrupted.
And then followed by, if I may, followed by they say, yes, once again, Milord, kindly come to paragraph 11. Several non-trained candidates were appointed.
Yes.
Now, the Lordship will go by the principles of a deemed pleading. I shall satisfy from authorities that the court, whose duty is to, Lord, find out the truth, should not strictly confine to the words of the pleading, but they have to also consider the deemed pleading. Here, pleading is categorical. Apart from 2014, where CBI investigation is going on, I shall also place the CBI charge sheet. Even in case of selection, non-trained candidates were appointed. Then the paragraph 12, about example given to Mr. Y. Now, this Y is relating to recruitment in 2016 selection process.
So if it is to be deemed that the 2016 process was also under,
Also under.
then where is the prayer to that effect?
Yes. Now, may I place little more?
Just a question.
Yes. Lord, kindly come. Let us come to the prayer of the repeat. No. It's better to satisfy the queries of the court first. Lord, kindly come to the prayers in detail. I to direct the authorities to file a report disclosing name, numbers, rank, category of all non-trained candidates who have been recruited till date in primary schools from date 2014, including the date of recruitment. Then direct the authorities to treat the petitioners equally with non-trained candidates who have been recruited by the board after expiry of the relaxation period.
That we understand.
Then kindly come to Lord 4.
By giving the same benefit.
5 is important. To direct the authorities to publish a merit list by maintaining full transparency regarding TET 2014 recruitment.
In 2014, you were qualified.
Sorry, Lord, I skipped Roman 4. To recruit the petitioners by giving them same benefit by which other non-trained candidates were recruited by the board following the rules dated 22nd March 2016 and appointment notification dated 26 September 2016.
So your challenge was that either give those persons or the similar benefit like the untrained, non-trained candidates were given.
But my prayer is, hello? Everybody, everybody is charged. To recruit the petitioners following the appointment notification dated 26 September 26, very important.
So what is the kindly address us that on the basis it seemed to us as it was argued that TET 2014 allegations are there, nothing to do with the selection.
Yes,
And that they would be satisfied in the event they are given appointment like those non-trained in the remaining.
No, but my argument would be, it might be not hurt many, that when the court finds there is many institutional corruption, systematic fraud played, starting from 2014 to selection, then I shall develop that. Now, to maintain the purity of the system and keeping Article 14 and 16 in the mind, court will be non-hesitant to set aside everything and do it afresh. Now, yes. Now, I am just to complete the paragraph 12. I have given the instance of Y, then 13. Your petitioner stated the candidate, namely Pulao Sarkar, was not empaneled Another candidate named Dhiraj Bandyopadhyay having roll number was not empaneled. Bishwajit Burman having roll number was not empaneled. But they were called by the department for verification of documents, and from sources, the petitioners came to know that they were working as primary teachers. Look, this is fundamentally attack on the entire selection process. Look, how these were dealt with by the affidavit, I shall place it. Then this paragraph 13 says there was huge illegality.
Paragraph
13. Well, though there was huge illegality in the whole selection procedure of, it should be not 2014 selection process 16, and everything happened as per the wish of the board. And for this illegality, the candidates like the petitioners could not get appointment as primary teachers. Therefore, this relates to the selection.
yes.
Then Miller, serious allegation in paragraph 15. Your petitioner further states that on 30th April, so-and-so, I am not naming, made a statement before the media pointing irregularities in TATE panel. Recently, a person lodged a complaint against one MLA of All India so-and-so. That MLA took crores of money from job aspirants with a promise to give them government job in school, and in that case, personal assistant of one another MLA was arrested. The Constitutional Court would definitely not go deep into it to do complete justice and uphold the constitutional principle. Then paragraph 16, your petitioner states that the TATE 2014 examination is the biggest scam in West Bengal since 2011. Then Lordship may skip over paragraph 17. Your petitioner states that TATE 2014 is the biggest scam of the education department so-and-so. MLA, MP, leaders of ruling party are involved, and meritorious students who qualified for the job did not get chance. And after talking to the candidates, petitioner came to know that roughly such and such amount was given for job in TATE 2014. Well, a job cannot be taken.